Thank you. Please be seated. Good morning. This is the time set for oral argument in our consolidated cause numbers CC13-0002 and CC14-0001, Residential Utility Consumer Office versus the Arizona Corporation Commission. Council, we are recording today's proceedings, so when you step to the podium, please identify yourself and the client that you represent. Each side will have 20 minutes for argument, and Appellant's Counsel is responsible for watching the clock and reserving any time for rebuttal that you may desire. In terms of the appellees, the Corporation Commission and the intervener can divide their 20 minutes however you wish. We've read the briefs, we've conferenced the case prior to argument. I think we have a fairly decent understanding of the procedural history, and so you may want to abbreviate a presentation regarding that because I think there are some interesting legal issues that we'd like to spend more time on than procedure. With those preliminaries out of the way, counsel for the appellant, you may proceed.
If it pleases the court, my name is Daniel Pizewski. I am counsel for RUCO. We're here today to discuss whether a new rate surcharge mechanism called a Systems Improvement Benefit Mechanism, or SIB, complies with Arizona's constitutionally mandated fair value requirement. RUCO maintains that it does not, nor does it fit any exception to fair value. In other words, RUCO maintains it is illegal.
Counsel, why does our Constitution require that the Commission determine fair value in setting rates? What is the relation between fair value and the rates that public utilities can charge? Or what's the theory behind that?
Your Honor, it's as a general principle, the courts have frowned upon companies recovering individual costs, such as planned costs and earning a return on those costs in between rate cases, because it streamlines the important process of the rate making or rate cases where all the different elements are considered. I'm getting to your point.
Because my question is even more general than that.
Right, and this is a very esoteric issue, and I
need to get too far in the weeds. I want to get the general concept.
The general idea is a rate application and the process that's involved in coming up with fair and reasonable rates usually entails a forensic study of a company's financial situation. So not only do we look at the actual plant and the rate base that's being considered, we consider all the other aspects to it, such as the operating expenses, all the synergies, all the savings that are involved. If you put new plant in, for instance, you're going to have less repairs, things of that nature. That's what we do in a rate case. We look at all the different elements in a rate case to ascertain fair value or to ascertain a fair value.
Kind of a holistic approach.
It's a holistic approach. Now, where it gets a little squirrely is when we try to do this notion of single issue rate making.
Well, I think in addition to the very interesting constitutional issues, we're interested in the policy implications of ruling one way or the other, not the policy reasons for whether a SIB is a good idea, because that doesn't really affect the constitutional analysis. But so what is wrong with, I know courts say piecemeal rate making is a bad thing. Tell us why.
Okay. The reason why is because you're looking at one thing, and this case is the epitome of it. We are at a crossroads on this. And let me make this point because it's critical. What's going on with the SIB, Your Honors, is the Commission has adopted a mechanism where basically there's a finding in a rate case where all this is done, there's a fair value rate base, and each year for up to 5 years, what the company is going to be able to do is they're going to be able to put in their gross plant less depreciation in between rate cases. The gross plant less depreciation, what the Commission will not consider in the calculation will be the expenses, will be synergies or savings to ratepayers, will be such things as advances that are made in advances in aid of construction and contributions, which are reductions to the rate base. All those things in each one of these steps won't be considered. And why this case is so important, why we're really here, is because what we're actually talking about now is what every company would like to do. They would love to be able to run their gross plan through the commission in between rate cases and not have anyone looking at any of the actual adjustments or calculations or adjustments to that rate base, that gross plan. Now, you're going to hear about how there's all sorts of reporting requirements, but keep in mind, even though there are reporting requirements, there are no adjustments to the calculations. That's the key here, to keep your eye on the target. There's no adjustments to those calculations that are going to be made at each step increase. All that's going to be considered for fair value rate base is the gross plan less the depreciation. And so let me give you an example. It goes out for 5 years, okay? Up to 5 years, they'll have 5-step increases. So in the 5th year, you'll have adjusted that rate base that you determined in the rate case. That will be the 5th time you'll have adjusted it, okay? But the operating expenses that you're going to be considering then, and the rate of return, for example, are all going to be the operating expenses that was determined in the underlying rate case. The rate of return, for example, that is going to change. It has to change because there's different risks. The cost of capital is changing as time goes on, but we're not going to reflect that change in the actual calculation of the fair value rate base or the rate base on the 5th time. So, for instance,
Can I interrupt you?
I'm sorry.
I mean, there's such limited time, and I think all of us have some questions. You've used the term step increase a fair number of times, and labels to some extent don't matter, except my reading of our jurisprudence, only 2 recognized exceptions to the constitutional requirement exist, an interim rate and an automatic adjuster clause. So, and I want to hear from the commission because I think their view has evolved over time. The commission specifically found this was an automatic adjustment mechanism. Now I hear them saying on appeal it's a step increase. Take me through, if you would, interim rates, automatic adjuster mechanisms, and step increases, and tell me why this doesn't work. I don't think a step increase is an exception to the constitutional requirement, but tell me why it's none of those things.
Okay. But I do want to get back after I do to the step increase because that's critical.
I want to hear about the step increase too.
There is a case that the company and the commission are hanging their hats on.
The Community Action Association
And I've got
case,
a
and I
distinction.
understand there's some significant differences, and that's what I want you to hone in on. Why? But first, let's talk about the 2 recognized exceptions.
So-
Is it your view that it's not an interim rate because no emergency?
Start with the automatic adjuster that was done in skates, okay?
Why do you want to do that when I asked you about interim rates?
I'll do either one. It doesn't matter. Interim rates, this court, there's 3 requirements for interim rates.
Yep.
Emergency guarantee, as you know, a bond with a guarantee, and then a rate case that follows. There's no emergency. No one has alleged that there was an emergency in this case. The other thing about interim rates is there's a guarantee, okay, subject to a refund. So what you're talking about is interim rates such as you have a rate case, it takes too long to get the final rates, we have interim rates. What happens in that situation is that holds you over, and then at the end of the rate case, if the rates are determined to be higher or lower than the interim rates, there's a refund, okay? We don't have a refund situation with the SIB.
But isn't it sufficient? I mean, I know that the commission sort of tries to argue that Pueblo del Sol, or whatever the name of the case is, said that they're disjunctive. They're clearly conjunctive. You have to have the three criterion to qualify as an interim rate. So if there's no emergency alleged, no emergency found by the ALJ, the commission, anyone, isn't that the end of interim rates?
In our opinion, it is. This is just routine plant being offered. Yeah, it's $67 million is what it's estimated, but there's no emergency. It's routine plant. There's nothing special about this plant.
Okay,
It's
what about
nothing.
automatic adjusters? I'm trying to move
Let's
you
get
along, 'cause
back to,
you-
yeah, because there's a lot to share. Automatic adjusters, Your Honor, is what we use to pass through basically costs such as fuel costs, where the companies make no money on fuel costs. Okay, so there's no, you can't have a rate take case every time a fuel cost goes up. That was the idea behind it. That's why it's limited to narrowly defined expenses. What we're talking about here are capital improvements, plant. That's what this is all about.
Well, in
This
fact,
is-
they're anticipated capital improvements of the plant, aren't they?
well,
Does
that's
anyone
right.
think when they put that plant out there that they're not going to need in the future to set aside monies in order to go in and revitalize or relay the pipes or whatever term you want to use?
Yeah, you're exactly right, and that's important because it's not plant that's already in construction, in progress.
This
which
is not a CWIP.
Right, construction work in process, which is the Arizona community case. So there's no connection between the rate base, construction work in progress, plant that's already in progress. The idea is to get that done through, so we don't have successive rate cases. That's what we're.
Step increase.
That's the step increase that we looked at in Arizona community. Here, we're not doing that. Here, we're looking at new plant that's coming after the test year that's going out for 5 different step increases. Completely different situation. No connection between the two, and that's what the court was trying to address in Arizona community. And that's why that's so different than this. We're not doing that here. Remember, Arizona community wasn't an exception case. That was the fair value case. They said there was enough of a reasonable connection between what they were doing, the construction work in progress, and going out. Plus, in Arizona community, we went out 2 years, unlike this case where we're going out 5 years. The cap in Arizona community was 5% 2 years, cumulative 10%. Here, the cap is 5% per year up to 5 years. That's 25%. So we're at twice the cap. We're at twice the amount of years, and yet they barely found that there was a reasonable compliance with fair value in Arizona community. And they said to the extent there was, it was because it was for a limited, very limited period of time, 2 years. Critical distinction. This is going out 5 years, okay? So you can see why we're so concerned. If a company can put through its gross plan in between rate cases for a period of 5 years at such a high cap, and we talked in my briefs about how that's going to affect ratepayers. It's going to affect them in most cases more than the actual rate increase. Then they've done what we can't do by proposition. We tried in 94, 96, and 2000, as the Supreme Court took acknowledgement in the U.S. West case in 2001. So they've essentially gutted fair value. And this is why we can't do it. So those are the two exceptions, Your Honor. I hope I got to the thing about automatic adjusters. The other thing why it's important is because when you talk about expenses in that context, what Skates Court said on expenses was that, yeah, you're going to raise those expenses, and that's going to raise the increase, but the important thing is you're going to keep your operating income the same. Right? What we're doing here with the SIB is we're raising the rate base. The rate base times your rate of return equals your operating income. So your operating income's not going to be the same. It's actually going to be going up. So a complete.
What about that dicta in Skates? What do you want to tell us about that? Has any court ever built on that beginning at Head Note 7 where Judge Schroeder talks about, well, this isn't the case, so we don't decide whether an exceptional situation could exist where the commission could authorize partial rate increases. Has any court in Arizona built on that to carve out some additional expanded exception to the fair value determination requirement?
Not that RUCO's aware of, Your Honor. Not that RUCO. They've alluded to it in the Skates case, as you know, that there's that possibility, but no court has come out and said that third exception actually exists. And here's another thing. If, in fact, there is fair value, as the commission alleges, the company, how can it then be also subject to all 3 exceptions, which is also what they allege? If it's the adjuster, the interim, and this third value, which if you did approve, you would be creating law, completely new law. And remember, when it comes to exceptions, Your Honor, it's a basic tenet in law that with exceptions, the idea is to narrow them, not to broaden them. And that's exactly what the commission and the companies are proposing to do here, is to broaden these exceptions. Your Honor, with the rest of my time, I'd like to save it. Thank you.
Thank you.
Good morning. Wes Van Cleve representing the appellee, the Arizona Corporation Commission in this matter. And I think what we're asking the court to do here, obviously, is affirm the decisions that are under appeal in these consolidated cases. And I would like to reserve approximately 5 minutes of my time for the intervener to speak if time does permit. But from the outset, I think it's important to note that the appellant has the burden of demonstrating by a clear and convincing showing that the Commission's decisions in this case were either unlawful or unreasonable. And I submit they haven't met that burden. What this case is about is the Commission's constitutional authority to set just and reasonable rates through the System Improvement Benefits mechanism that's at issue here. And what that mechanism does is enables or facilitates the company being able to replace certain infrastructure in a way that balances the public interest. It enables the company to replace infrastructure that in this record has been demonstrated to be declining in its aged infrastructure that's failing. And this.
But doesn't the company come in alleging an emergency that requires this interim rate hike, interim modification, where clearly it's something that was calculable and discernible at the time of the last full rate hearing?
I don't know if the company ever came in and said it's an emergency. I think, and I would just say this at the outset, I think that the lens that the court needs to look through in this case is whether or not the Commission, in creating this mechanism, complied with the fair value requirement. That is what is required of the Commission.
Well, I think that's right, except I think Judge Jones' question gets to the interim rate issue. And I want to clarify what the Corporation Commission's position is, because in the proceedings below, it was the position that this was an automatic adjuster mechanism. That's what staff said, and that's what the decision says. On appeal, it seems like that has shifted a bit. So we need to pin down, what are you asserting in terms of the SIB? What is it? What is it? Does it fall within an exception, or does it comply with the fair value determination? What is the position?
I think our primary position is that what we've created here with this mechanism fully complies with the requirement of fair value in the Constitution and has been interpreted by the court.
Because it's a step increase?
I don't know that you have to necessarily label it as one thing or the other. Now, I know RUCO has taken the position that really the options on the table here are either the Commission has to set rates within the context of a full rate case, or it falls within two exceptions. And I think if you look at the constitutional provisions here, which are primarily Article 15, Section 3 and Section 14, there's no reference to the requirement of a rate case. And the only case that RUCO really cites to in support of that proposition is Skates versus the Arizona Corporation Commission. And I know they've spoken about that here today, but if you look, first of all, there's no reference to a requirement of a rate case in that case either. The holding of the court simply stated was that the Commission, when it sets a rate, must determine the effect of that rate on the company's fair value rate of return and must determine the fair value rate base of the company.
And isn't that the mechanism that has been created for the full rate hearings?
Not necessarily. The full rate hearing is something that is very encompassing, and I think I know RUCO criticized their language on this, that it's time-consuming, cumbersome, and expensive. And that really is something that really affects both the company and the ratepayers. The ratepayers will ultimately have to pay for the expense of that procedure.
So is there too much being done then at a full rate hearing, or is there too little being done at an interim hearing where a SIB is the issue before the Commission? Well,
keep in mind this mechanism was created in a full rate case. That's one of the decisions that has been appealed here for the Eastern Group and for the Northern Group. I think as it relates to the mechanism itself, that was created in the rate case. Then you have these surcharges that the company may file an application for every 12 months for a specific plant that, again, was fully evaluated in the rate case, and there's no dispute by RUCO that plant is in need of replacement.
But let me interrupt you to make sure I understand what your position is and isn't. I think from the record it's pretty clear that everyone agrees that the factors that will be considered when approving or disapproving a surcharge under the SIB, much less information will be considered by the Commission than in a full rate case. True?
I would agree with that.
And, for example, they'll be looking at the capital expenditures, but they're not going to be going back and looking at how does this affect operating costs, how does it, to use Mr. Pozefsky's word, create synergies or savings for the consumer. I know there's an efficiency credit that's built in, but So the question becomes, it's not what's required in a full rate case, it's considerably less. And so under what authority can we say that's okay, that's sufficient?
Well, and I would look at it this way, too, is I think that while it's something less than what would be in an all-encompassing rate case, it's not simply, they ask for a number or a surcharge and they get it. When they file their application, they're required to file updated balance sheets, updated income statements, they're required to file an earnings test, they're required to file what the final costs are for that plant they're actually seeking the surcharge for. And the commission then takes that information and it determines the fair value of the rate base with the inclusion of that plant, and further determines whether or not that surcharge can even go into effect by looking at what its impact is on the company's fair value rate of return. And again, I think that's what the Constitution ultimately requires here. I think primarily, to answer your question as to what it is, I don't know that you have to put a label on it, but I think in our briefs we've primarily stated that it is a step increase mechanism that fully complies with the Commission's constitutional fair value requirement.
At the next full rate case, does the Commission then go back to the last full rate case and do all the analysis of everything, including those things that they've done made the interim determinations in regard to?
Well, as a rate case works, typically a company will file an application for a rate case, and it uses a specific test year. So if they were to file like next year, which is actually under this mechanism for this particular company, for the Eastern Group, they're going to be filing a rate case next year using a test year of this year, and that includes all their expenses, all the plant that they may have included in that test year, and that is what's used as the basis for the actual rate case. And you look at what the expenses are, and then when you set rates, you look at what those expenses are, and they may be adjusted slightly to, if they were extreme for that particular year, to adjust them down, and then the rates are set. Now, the plant that actually goes through this mechanism, when you come to that follow-up rate case, those surcharges go away, and that is, I think, why we principally call this an interim rate of sorts, because those surcharges are not permanent. When they come in for that follow-up rate case, those surcharges get zeroed out. That plant that was going through that mechanism then gets rolled into the actual rate base of the company, and it's looked at in that rate case to determine whether or not that plant was somehow they're over recovering on it or under recovering on it. So it is looked at in the rate case, and it's looked at with each surcharge request, and they may not get the surcharge that they're asking for if it causes them to earn more than they were authorized to earn.
And I've said this before, but one of the things that bothers me a bit is the Commission found that this was an exception to the requirement for a fair value determination because it was an automatic adjuster clause. So I'm having difficulty squaring that with what you're telling us here today, which is we don't need an exception because this complied.
Well, I think, to your point, I think our position ultimately is, again, we have complied with the requirement of the Constitution and as the case law has interpreted it. But as to these exceptions, I know that there's definitively two exceptions. We do believe that maybe it's in dicta, but in the Skates case, or the community action case, that there is this sort of notion of a step increase. But we believe that with all the features and protections that we've put into this mechanism, allow it to essentially comply with the exceptions to the extent the court does somehow find that what we've done here for fair value isn't sufficient. I mean, with the adjuster mechanisms, I know the appellant has indicated and is arguing that those are somehow limited to narrow expense items, and I'll acknowledge that the cases in Arizona that have addressed those mechanisms have been in that context. But this isn't a novel mechanism. There are 11 or so other jurisdictions that have adopted a similar mechanism to address this very issue of aged infrastructure. It's something that I think ultimately the record in this case shows is affecting this state, it's affecting the country as a whole, and that was the purpose of the Commission developing this mechanism, was to address this looming infrastructure problem in a meaningful way while still...
And I started by saying policy considerations
Sure.
are valid for the Commission in many respects, but the Commission can't rely on policy to deviate from the Constitution.
Understood. And I don't believe we have, Your Honor. I think what we've done here fully complies with the Constitution. We have argued that it also, because of what we've done here, also falls within the adjuster mechanism exception. And to address a little bit the interim rate exception, I think that the one thing you have to look at in those cases is if you look at what the court has said on interim rates, you can really trace this back, I think, to an AG's opinion that was issued sometime in the 70s. And if you really read that AG's opinion, the context in which it's explaining interim rates is in the context of an ex parte interim rate where there's no notice requirement provided to the ratepayers of the utility because of the fact that there is some sort of an emergency that would somehow obviate the need for that as long as these other protections are here. You don't have that in this case. In this case, before the company files any surcharge request, it has to provide notice to its customers. And again, the fair value issue, the context of that AG's opinion was you don't have to determine fair value because to do so is more time consuming, and therefore you can simply rely on the fact that they have to post a bond that would allow for some sort of refund if the rates that are ultimately set in the follow-up rate case were lower than what the interim rate was. Here you have fair value being looked at, you have notice being provided to the customers, and ultimately you have the commission analyzing that information, and when it authorizes a surcharge, it's complying with what the Constitution requires of it. And I guess I would just, I don't know if you have any further questions for me in this regard, but I would just finish up by saying again, you know, the core function of the commission, it's a unique agency. This function of rate making is set forth in the Constitution. There is really no sort of instruction manual that explains exactly how the commission is supposed to use this authority other than the case law that's been developed. But I think that that authority isn't necessarily confined only by the case law that's been developed. That simply explains where the commission has to do certain things in those particular cases. And we believe here with this mechanism that we've created that we are complying with the Constitution. And I don't know, again, I don't know that you have to put a label on it, and I certainly don't think that RUCO's contention that the options are either a rate case or one of these two exceptions. I think you really have to focus in on what the Commission did when it set the rate. And I would just point this out, is if you look at some of the cases that have developed, such as the ones that have been talked about here today, like the RUCO case and the Skates case, if you look at what the court's criticism was there, is that when the Commission set those rates, it didn't look at anything. And that was the ultimate criticism. And I know there's been this issue of piecemeal rate making is frowned upon, but the piecemeal rate making that took place in the Skates case was the fact that they increased a rate for a certain service to the telephone company without looking at anything. And that isn't the circumstance that exists here. We've looked at updated financial information when we go to authorize these surcharges. We look at whether or not it's going to cause them to earn more than they were authorized in the prior rate case. And with those protections, we believe we have fully complied with the Constitution. And with that, if you don't have any questions, I will pass off the rest of my time to the intervener, Arizona Water. Thank you.
Thank you.
Morning. May it please the Court. Steve Hirsch from the firm of Bryan Cave, representing the utility, the original applicant here, Arizona Water Company, the utility who put forth what was initially known as a DISC and morphed into a SIB and went through 3 different layers of hearings with expert witnesses on 2 different reconsiderations and produced a record that we would observe is extraordinary in terms and I'm sure entertaining, as it was extraordinary, in terms of the, not to dwell on public policy, but the justifications for this mechanism. But let me zero in the catbird seat of kind of coming up, listening to Mr. Brzezinski and Mr. Van Cleve here on a few of the issues that seem to have intrigued the panel on this issue. The utility applicant intervener, Arizona Water, feels that the fair value constitutional requirement has been met. Our contention would be that you don't get to the exception analysis, but if you did, that the public policies underlying those cases, those that address interim rates and those that address adjuster mechanisms, this fits. But it is really, I'll admit, neither of those. But then it is, in a sense, both of those. Let's explore what it is, because I think there's a general misunderstanding, and it's a prolix rate-making vehicle here. But it's important to drill down as to what the utility has to do to make its case to recover these surcharges. Mention is made in Ruco's opening argument of utilities are poised to run their gross plant through this mechanism and get these interim rate increases. None of that happens under a SIB. A SIB relates only to a specified amount of non-revenue generating plant. Think of maybe 2 blocks long of new line in Bisbee, Arizona that is being put in. The only recovery that's allowed on that as a public policy incentive to have the utility spend the funds to do that and to attract the equity investment that's necessary to spend those funds, all they get to return while they're waiting for their next rate case to be filed is partial depreciation, okay, a per year payback on their hard costs they have into that pipe, which otherwise is foregone. They never get it until the next rate case, and a return on the equity investment until the next rate comes. Only a few years. We're not talking, these are insubstantial funds when it comes in the big picture of rate making.
Let me interrupt you because I understand there's a lot of information submitted with the surcharge applications, but isn't the nut of Ruco's complaint that the Corporation Commission will only be analyzing how the SIB affects the fair value rate base? It won't be considering fair value beyond the SIB's effect on it.
Well, I think to prevail here, Ruco has to persuade you that this is a Skates case, or it's a Ruco case.
I'm just trying to clarify what it is. My understanding from reading much of the record is that what they're looking at in this 5-year period is the effect of the SIB on the rate base, on the fair value rate base. They're not looking at all of the other factors out there that affect the fair value of your client.
Or affect the return on that fair value, to more properly pigeonhole it into the cases. The direct answer to that question is SIB forces the utility to do that. There were aspects of it that didn't as it was initially proposed at the beginning of the rate case years ago, but through these rehearings and these hearing trials after trials and in the settlement room that Ruco ended up not participating in, all of those concerns were addressed. Let me give you a mini primer on what the utility has to do to earn a SIB. Okay, you start with general rate case number 1. You have to come in and show, and we do feel an emergency was shown. There has to be a separate engineering study.
Where is that in the record? Where was it claimed? You said extraordinary, you said exceptional. I don't see any claim that it was an emergency. The ALJ found it wasn't an emergency. The Corporation Commission didn't find it was an emergency. You might have a better argument.
Well, it is an extraordinary circumstance that arises only in a few systems in Arizona, like those in Bisbee, Winkleman, et cetera, old, often mining properties. We had pieces of evidence in. I'll acknowledge it is not a traditional interim rate case where there's an emergency, but I will also tell you the record is replete with pictures of geysers coming out of parking lots at an auto parts store in Bisbee and pieces of pipe that look like coronary arteries at the Arizona Heart Hospital that are about ready to go because of the corrosion that occurs. And the problem under the pre-SIB and the states that have not caught up with adopting SIB yet is that the current rate-making structure makes the utility wait until they come back into a full rate case to get recovery for that extraordinary infrastructure replacement that's needed.
That may be bad public policy, and maybe the Constitution's outdated, but we can't overlook what the Constitution requires. I'm just trying to get you to tell me, and I want Mr. Pozeski to tell me his view of what it is. Everything I read is that they are not doing a fair value determination of the overall utility. They're looking at how the SIB affects the fair value determination only. Is that accurate or not?
It's a 3-step process. General rate case, everything is looked at. There's a master facilities report that's done where the utility proposes several dozen, if they want, different segments that might be eligible for SIB treatment. There's a full rate case and analysis over the cost and the fair value implications of each of those. In step 1, the rate case, the commission authorizes which of those will be eligible for SIB treatment. Unlike the cases where such step mechanisms are struck down, that's not the end of the game. Arizona Water just doesn't go to the pay window and recover. They then have to front the dollars to build the pre-approved improvement, fill out these very onerous book-like forms to address fair value rate base, to confirm that a rate of return isn't exceeded. That's submitted to the commission. It doesn't go to a full rate hearing because that would be onerous and completely inconsistent with fair rate making. But there is a trigger where the commission can say, we're not satisfied, either you don't get it or we're going to have a full hearing. Okay, that's baked into the middle level of SIB. And then the third protective step is there is a full traditional next rate case where the SIB surcharge goes away and the overall impact on fair value rate base is analyzed. And U.S. West, I'll close,
Yes.
is instructive here, Justice Lackett's opinion, because RUCO argues that fair value, it's a very formulaic approach, and that you must have a full of the entire plan and property of the entire eastern group.
Not a regulated monopoly case.
Well, but it is a case where both constitutional provisions at issue were explored, and Justice Lackett, as you've seen, stated it is not a formula approach that requires it at every turn. It just simply must take into account fair value rate base, and our contention is that it's done so here, and that SIB is compliant with that requirement.
But he also goes on to say that in a case of a regulated monopoly, the traditional formula applies, doesn't he?
Yes, but there's nothing about SIB that isn't the traditional formula, which is fair value rate base, then plus an expense component on top of a return on the fair value rate base. That's built in at each step, and each surcharge doesn't go on the customer's bill until that case is made at the commission at each layer along the way. Thank you.
Thank you. Can we give Mr. Pozesky a total of 8 minutes, please? Can we give him a total of 8 minutes for his rebuttal, please?
Thank you again, Your Honors. Let me start by making a few points here. Both the company and the commission seem to be confused and have been on RUCO's position. They've been consistently saying that RUCO believes that only a full rate case would satisfy the fair value requirement. Nowhere in our case have we said that. If you look at page 14 where they cite that, it says generally fair value is found in a rate case. That's generally where it's found. We acknowledge community action. Community action, it's funny, it's what's been used by the company and it's been used by the commission to hang their hat on, but if anything, it supports the argument that we're trying to make. It showed you how strained, and it's strained to find that connection to say that it could result in fair rates. It's strained to do that, and that was with 2-year step increase, and that was with a 5% cap per year. Again, I remind you, we're going out 5 years, we're going out 25% total cumulative allowed, okay? That, what we're also doing here is don't dismiss the effect that this is having as far as the total effect on what it's going to be. I know that I didn't articulate that well, but if you look at this SIB, it does involve 5 accounts, but they comprise 70% of the company's total plant. This is a big deal, and in all the other cases we've appealed that are before, you'll see it has a big deal. In this case, the BISB folks will see base rate decrease by 55% as the result of the Commission's Phase 1 decision, okay?
Can I interrupt you? Because
Sure.
my concern is maybe more elemental and more tied to the constitutional requirement than where you're going right now. Can you tell me specifically how the SIB mechanism falls short of the constitutional requirement that the Commission determine fair value? How specifically?
Okay. And the reason why I think you're having this difficulty is we all struggle with this in our challenge is there's no formula for fair value. Courts have not said that there's a formula. The courts have only said companies or commission, you have to find fair value. We're not going to tell you what it is. We're going to tell you have to find it. Our point here is they haven't found it. It has to mean something more than putting in gross plan for 5 steps in between rate cases. It has to mean something more than that. And doing that, and what it means, we believe, is that there has to be an evaluation, there has to be a connection, an evaluation of not just the gross plant, but all the adjustments or some sort of consideration to protect ratepayers. Because if you don't have that, if you do what the SIB's requiring, then fair value is meaningless.
What about the efficiency credit?
It's so minuscule that it's not even relevant. It's 5% of the total SIB revenues, which I think at one point an analysis was given to me. If you had $1 million a plant with a rate of return of 10%, that'd be $100,000. 5% of that would be $5,000. I mean, that's one for the numbers guys to run you, but you get an idea. If it's $1 million a plant, $5,000. It's not nearly what it would be if you actually looked at all the different offsets and the different adjustments that would go to ratepayers if there was more of a process.
Okay, so it doesn't have to be a full rate case. What, in RUCO's view, could be added to the oversight of the SIB requests that would bring this within constitutional compliance?
Well, obviously, if it was done and formatted the same way as what was done in Arizona Community, the Supreme Court, although, again, there's not that connection that you had between because, again, what was
limited period of time and work that was already in progress in
Right.
the context of a full rate case.
Yeah, we wouldn't argue that would muster fair value requirement. There was we agree with the court. There was enough of a connection there, so it could result in fair rates. But we're way beyond that with what we've got here. This is troublesome, and you're right. Policy considerations aside, it still must meet the constitutional requirements. It still must meet it, even if there are good policy reasons for it.
And what if, assuming for the sake of argument, you were correct on the fair value issue? What becomes of your second issue on the return on equity?
Well, then the return on equity would stay at 10.55, assuming you didn't remand it for any reconsideration of that. So the SIB would be determined, if you determined it was unconstitutional, the SIB would be determined unconstitutional. The case would stay at 10.55.
And is the 10.55 validly arrived at in this case?
You know, on that one, there's evidence in the record that would support it, Commissioner, or Your Honor, so I don't think it would be an issue that, under the circumstances of this case, you understand we've made the argument that it's arbitrary because the 10.55 was what originally the judge who originally looked at that had said we're going to give to the commission, or we're going to give to the company because we're not going to award a DISC because there were too many red flags and that a DISC wasn't warranted. And by the way, the fact that 11 states have it, I think that dates back since the 1980s. That's 39 states that don't. So if it was that wonderful of a mechanism, and of those states, we've got to question how many of them have fair value. I think Arizona and maybe Michigan are the only ones that have fair value. So we have a whole different regime here.
Do you continue to be concerned that compensation on the rate of return of equity, at 10.55 is duplicative of other compensation?
Yeah, and the commission said it. I mean, it's not, if you look at the plain word of their Phase 1 decision, it said that they were going to give them that. First, it recognized the Western Division case, which was 10% without a SIB or a DISC. And it said, because we're not going to give them the DISC, in that case, it wasn't a SIB at that time, we're going to give them the 10.55 to account for the infrastructure issue, which they recognize that there's an infrastructure issue. And then, as you know, from there it went to Phase 2, and in that it was instructed, hey, look, you got to come up with a DISC-type mechanism.
So they get the 10.55 plus the DISC.
Plus the DISC, which the DISC is, no one disputes that that's also for infrastructure, same infrastructure. So it's duplicative, and in fact, both ALJs, one ALJ, because it was the same one, had found on 2 occasions that it was duplicative. Of course,
then violate the constitutional requirement of determining fair value.
No,
Okay. Because?
No, I think that's a different argument. The 10.5, they have the discretion, and there's evidence to show. The question of fair value goes more to the rate base. The rate of return, obviously, is another part of operating income, what you multiply that fair value rate base by to come up with your operating income.
Thank you.
But that's not to say that one doesn't affect the other.
That was actually my point.
Right.
Thank you.
Thank you, and I appreciate your time.
Thank you for your arguments. We will take this matter under advisement and issue a ruling in due course. At this time, the court stands adjourned. Thank you.